My name is Mark Sarek. My practice is focused on civil law matters, including real estate, property, construction law, and business. And in some cases, our firm retains consultants or experts to work towards a resolution for our clients. Our firm uses experts in a range of matters. In business cases, sometimes forensic accountants are required. In medical or personal injury cases, doctors can be retained to review medical records and perform independent medical exams, and sometimes experts are required to review invoices and medical billing codes. In construction cases, a lot of times we work with engineers and general contracting experts. Under Arizona law, claims against licensed professionals in a civil action require that the claimant or the claimant's attorney certify in a written statement that is filed and served with the claim whether an expert opinion is necessary to provide the licensed professional's standard of care. If an expert opinion is necessary, a preliminary expert opinion affidavit will be served with the initial disclosures. A claimant can provide as many affidavits from experts as necessary. Expert affidavits must include information concerning, number 1, the expert's qualifications, number 2, the factual basis for each claim, number 3, the professional's acts, errors, or omissions that the expert considers to be a violation of the applicable standard of care, and number 4, the manner in which the licensed professional's acts, errors, and omissions caused or contributed to damages or relief sought by the claimant. If the claimant or their attorney certify that an expert is not required, then the defendant can dispute the certification in good faith and apply by motion for the court to order the claimant to obtain and serve a preliminary expert affidavit. If the court determines an expert is required, then a date will be set by which the complainant must comply. The court, on its own, or the motion of the licensed professional, shall dismiss the claim against the professional if the claimant fails to file and serve a preliminary expert opinion affidavit. A claimant can and will supplement the preliminary expert opinion with additional claims, evidence, or opinions. Under the Arizona Rules of Civil Procedure, the parties will exchange expert reports that outline their expert findings in detail, which allows the parties to assess damages in a case. A party can use the preliminary expert opinion affidavit for any purpose, including impeachment. Expert reports are helpful in bringing the parties to the negotiating table. Experts can help define and provide the basis of identifying how to settle the case. While a case may require multiple experts, the general rule in Arizona is one expert per issue. This is known as the one expert rule. In other words, unless the parties agree or the court orders otherwise, each side is entitled to call only one retained or specifically employed expert to testify on a single issue. Nothing in the one expert rule, however, prevents factual witnesses from offering their opinions so long as that opinion is based on personal observation. There's a range of issues that experts can speak to. In some cases, experts can provide advice on matters of delay and disruption, program management, planning and programming, and construction and engineering disputes. Project management cases may involve looking at life cycles, delivery, and evaluate the performance of a project manager. In such cases, experts can identify the reasonable skill, care, and diligence to be expected. Sometimes professional consultants can act as managers on projects to provide advice on dispute avoidance, dispute resolution, and strategic decision-making. If you want to know more about this, or if you have any other civil, pre-litigation, or litigation-related questions, please reach out to us. We would be glad to talk to you and help you get answers.